Life Unrehearsed on CJAD 800. Brought to you by Marco Vendramini of IG Private Wealth Management. MarcoVendramini.com.
And good afternoon. Welcome to Life Unrehearsed, a show about the ins and outs of family life. So your life isn't going exactly as planned? Well, you're not alone, and we're here to help out. My name is Matt Del Vecchio, specializing in free retirement home search and senior transition support. In studio here with my co-host Corrie Sirota, clinical social worker and psychotherapist specializing in grief and loss. Coming right up on Life Unrehearsed. You know, as we age, we start thinking more about which legal documents we should have in order. Well, there's a difference between thinking about it and actually doing it. Are your wills up to date? What's a power of attorney? What's a protection mandate? It can be really confusing. And what is the difference of them all? But we do need to take this very, very seriously. That's why we have one of Montreal's finest notaries in studios to navigate us through it all. Corrie, it's going to be very interesting. I learned a lot, and I thought I was up to speed. So it's going to be coming up right very shortly. Mm-hmm. Corrie, I have to talk about legal documents and a shout out to Jamie Benezri, right, owner of Legal Logic, pulled off on Thursday night at LinkedIn Awards and Town Hall, and I was very privileged to be a presenter for the category of wellness, and it was a heck of an event, a big turnout, and kudos to Jamie and his entire team. A fun event and a lot of inspirational. There were 10 different categories, and you know what? Montreal's in very good hands.
Well, it's so great to hear, but I saw a lot of that actually on Facebook, and I know so many of the people that were nominated were really top-notch people. So it's great that he's doing that, and people are working hard. So to acknowledge them too, and all of it at the end of the day was also a fundraiser.
That's right. It was for the Lakeshore General Hospital Foundation. They raised a lot of money for that, and a great cause, great people, and there's some wonderful entrepreneurs out there. In fact, Jamie will be a guest on our show on October 14th. We're going to be doing a rapid-fire Q&A for legal questions.
Love chatting with them. Okay, so speaking of great people, on the second half of the show, we also have a very, very great person coming in to talk with us. This is a woman who only 8 years ago, her husband died by suicide, leaving her a single mom of children that were 2 and 2 weeks old. So on the second half, we're going to talk about how Paula Toledo not only learned how to manage and cope with this tragedy, but became an actual inspiration to many, many other people through helping understand how to manage grief and loss. She's also a TEDx speaker, so we know she's going to be great.
An amazing person. She's in studio with us right now, and that will be after the 4:30 news. Right. Can't wait to hear about that. All right. Corrie, I was amazed to hear that about 50% of the Canadian population over the age of 50 still do not have an up-to-date will. And that's just a will. You know, what about the power of attorneys and protection mandates and all these other legal jargons that we may not know about? It is very confusing, and that's why we're very pleased to have in studio notary extraordinaire Nadia Re Riggi to help us out. Nadia, welcome to Life Unrehearsed.
Thank you. Thank you for having me.
Well, thank you for coming in here. You are dealing with such important topics that we tend to put aside, and we probably shouldn't. But I think let's try to clear the air with some general terms. I think we've all heard about a will, but let's define what a will does.
Sure. So I think that's a really, really good place to start. As you said, 50% of the population does not have a will at all. So not only do they not have an updated will, they don't have a will whatsoever. I think it's so important for everybody to have one and really to give it some thought. So a will, when you're looking at a will, in Quebec, it's defined by our civil code. So it's defined in Article 704 of the Civil Code. And it's defined as being a unilateral act. It's defined as being a revocable act. And it's an act in which someone can dispose liberally of his property to take effect after his death. So what that means is that it's a document in which you can leave instruction for the transfer of your assets to your loved ones after your death. So it's a way for you to keep control.
To summarize, then, a will is really a document to demonstrate the transfer of assets.
Yes.
And the reason why I'm saying that, because that's going to come up in a couple of our other definitions.
Right. So there's a will, and then there is also things like power of attorney. And I
Right.
think people tend to get that confused. So can you please clarify that?
Yes. So a lot of clients do confuse the legal documents. A power of attorney is not for everyone. Power of attorney is a contract in which you appoint someone and you give that person either specific powers to act on your behalf for a specific act. So, for example, I could write a power of attorney for you, Corrie, and I could say, Corrie, I'm going away next week, but my house closing is next week. Can you sign the deed of sale? So that's a specific power of attorney. And then you have a general power of attorney. So we see this often with elderly parents who perhaps are well mentally, but physically can't get out as much. So they draft a general power of attorney in which they appoint their children to act on their behalf for everything. So that's what a power of attorney is. So not everybody needs one. Definitely everybody needs a will.
Mm-hmm.
And then I think what everybody does need is a protection mandate. So
just on that note, you're listening to Life Unrehearsed. That's Nadia Re Riggi, a notary, discussing our legal documents. And as you know, Nadia and Corrie, in my world where we help moms and dads find retirement residences, so often there is a power of attorney and an adult child, for example, who's designated to sign, can sign a lease. But so often I run into situations where there may be a case where mom or dad is inept, they might have Alzheimer's, and I get, well, it's no problem. I have my power of attorney, so I'm just going to sign the lease or I'm going to sign the banking documents, and then big panic hits when they realize that power of attorney is not going to go very far. So you talked about a protection mandate, right?
Yes.
Is that the next step?
That is the next step. And so it's very similar to a power of attorney in that it's a contract that allows you to name somebody. So you appoint somebody to care for you and to make your decisions. The difference, though, is in the person's capacity to instruct their attorney. So if I'm giving you power of attorney, it's because I'm apt and I understand what's going on. But from the moment I'm declared inapt, then we look to see, did this person write a protection mandate in anticipation of his incapacity? So in anticipation of that, you can say, I would name my husband, I would name my children, I would name Matt Del Vecchio as my mandatory. So that is the big difference. It's in the capacity of the mandator, or the person giving the authority, and it's in the timing on when we use it as well.
So let's be clear, though, about that. You have to be of sane mind and body in order to give someone that mandate.
Absolutely.
So what happens if, because often, I'm sure often or more often than not, there are people who become perhaps experience dementia, for example.
Right.
And they now no longer, if I'm understanding you, no longer have the ability or the right to sign a legal document. So what does someone do then? That's
a really good question. And actually our civil code covers for cases like that. And so all of this is set out in the civil code. And what it says is that it depends on the degree of the incapacity, but there are basically 3 types of legal representation that we can request from the courts. And it's all based on the person's health situation. So are they fully incapacitated? Are they partially incapacitated? Is it a permanent or is it partial? Or is it someone who suffers from mild cognitive impairment who just needs a legal advisor?
Okay, so that helps us understand more. What we're going to have to take, believe it or not, a traffic break right now. But when we come back, I want to know what the biggest mistake you see people do or make regarding these legal documents. So we're going to hear
it's a very good question, Corrie. And we're going to hear a lot more about the definition of protection of mandate, because I think a lot of people, I hear it so often that, just review that one more time for me. And because it's important, where people are assuming they have these legal documents in their safe and they're covered, when in fact, oh my goodness, I didn't have that done. So we're also going to want to know about some of the recourses.
Right. So that we'll hear as soon as we come back from traffic.
Life Unrehearsed on CJAD 800. Brought to you by Marco Vendramini of IG Private Wealth Management. MarcoVendramini.com.
Welcome back to Life Unrehearsed. I'm Corrie Serrata with my co-host Matt Del Vecchio, and we are talking to notary Nadia Re Riggi. about our legal documents in order to help us get some sense of lots of terms, lots of confusion, but she is really helping us navigate that. You heard Elvis as I came in. Talking about a little more action, because we tend to procrastinate, a little less conversation, right? Well, we are absolutely advocating that you need to have these conversations with your loved ones. I know it's not easy, but it is a must.
It absolutely is a must. And I'm really pleased. We're getting texts coming in, Corrie, and this is such an important topic. The question you asked just before traffic, Corrie, I thought was very important. And Nadia, we're gonna put you on the spot here. So what's biggest mistake you see people make regarding their legal documents?
Well, I think the biggest mistake that I see all the time is that people think legal documents are done once a lifetime, and then we never have to look at them again. So they go to the notary when they're newly married, and then they put the documents away in the drawer, and then they never look at them again. Well, guess what? Life happens,
Life is
as
unrehearsed.
we know.
Yeah.
And things change, and so should your legal documents. So your wills need to be looked at. Your mandates need to be looked at. Either, I say generally every 5 to 10 years, but not only that, whenever something happens.
For sure, when something happens.
There's a wedding, a birth, a death, you need to look at your documents. Well, so that's the biggest mistake.
I would really like to go back to this whole concept of wills, because as a grief counselor, I meet with families who don't have some form of, think they have some form of. When I worked at a funeral home, it was a mess. Mm-hmm. So can you elaborate more on wills, the type of wills? I know a lot of people said, I wrote it down. Yeah. That's good. I'm good to go.
Sure. So our civil code actually provides or recognizes, I should say, 3 forms of wills. So you have the holograph will, which is a will entirely written by hand, dated and signed by the testator. So the testator is obviously the person writing the document. And then we have a will before witnesses. A will before witnesses can be written by the testator or by a third party or typed. And it's signed in front of 2 witnesses. The 2 witnesses will also sign, and each page is initialed. And oftentimes a will drawn up with a lawyer, that's what we refer to as a will before witnesses. Mm-hmm. And then we have the final form, which is a notarial will. So that's where you go and see your notary and you discuss what your wishes are. The notary will draft the document. The document is read before you and signed with you in the presence of the notary and a witness. What's really important to take away from that is that the first 2 types, the holograph will and the will before witnesses, will actually need to be probated before a court upon your passing. So they cannot be used automatically.
So can I ask you one little question about that? People will go online today and find something. Mm-hmm. And so those would need to be, let's be very clear, those would need to be probated.
Absolutely. So I have had clients come in and say, well, why would I pay your fee when I went online for $10? I got a will. And so then I like to explain to them that actually they may not pay the fees up front, but their estate will end up paying the fees in court. Yeah. So.
A very good point. You're listening to Life Unrehearsed. Matt Del Vecchio here with my co-host Corrie Sirota. We are getting educated here with some very valuable information from notary Nadia Re Riggi. Nadia, I want to go back and tell me if I've been listening well. Okay, so we've got the will. I've got my will. I have a power of attorney, and so that gives me some powers to sign documents on behalf of someone. They are apt, and they are aware of it. Next step is what we call a protection mandate. So you are apt when you're actually creating this protection mandate.
Yes.
You are assigning someone that could really speak on your behalf if you get into a situation where you are no longer apt. Let's say you are in that situation. I am no longer apt. There's this fancy term called homologation, right? Yeah.
And I'm looking it up actually as we speak on Google.
Okay, can you explain a homologation?
So what homologation is actually giving life to the mandate, or it's actually getting the approval of the court. So what it means is that we are enforcing the document and enforcing the contents of the document. So when you go and see your notary to drop a protection mandate, you're apt. And so the mandate is not in effect. It will only take effect once you're declared incapacitated by your doctor and also a social worker.
So the process to get it homologated is
Yes.
that you need a document filled out by a doctor, you're saying, and a social worker.
Correct. So any interested party can step forward to say Matt is not well, and
I've heard that a lot, by the way. Yeah.
I'm pleading the fifth there.
I do believe that his mandate needs to be homologated. What do I do? And so we work with families, we contact the doctor, and we contact a social worker to have evaluations done.
So after those evaluations are done, if you go through the public system, it could be an enormous amount of time,
Yes.
months and months and months. And
yes.
if you go privately, a little quicker, but you do pay for it. But let's say you get those documents now. Then it goes back into a notary's hands?
Yes, and we will bring it to court before a special clerk, and we'll present the mandate and with the evaluations as proof that this person does in fact need legal representation. And then it runs its course through the court system, and we wait for a judgment.
How long
in
would
return.
that take from the time it goes in your hands?
Generally, right now in Montreal, I'm seeing a long delay, and so I'm going to say from 3 to 6 months.
3 to 6 months after having those
yes.
documents completed by the
Correct.
doctor.
I mean, there are always exceptions, and there are ways we can expedite things, but generally speaking, it's a matter of months.
Oh, wow. Okay. So a text just came in. I'm going to put you on the spot again. How long should it take a power of attorney / trustee to settle a will after death? Can the trustee change the will after death if they are also the trustee?
Okay, so if I understand the question, there are a lot of terms in there that perhaps shouldn't go together. Power of attorney and trustee don't go necessarily together because we won't find the power of attorney in the will. So I think that perhaps this texter wanted to talk about liquidator or executor of the estate, the person called to settle the estate. In terms of how long it would take to settle, there's no set time. I would say, generally speaking, minimum 6 months, and it can take several years. So it depends on the complexity of the estate, and it depends what the assets are. And the trustee cannot change the will. No, a will is a legal document, and so the liquidator or the trustee has to abide by the contents.
Very interesting. We have time for one quick question here, Nadia. You mentioned something off air that something you see quite often. Common law couples make certain assumptions regarding a will.
They do.
So in Quebec, there are a lot of common law couples. Can you explain their rights?
Well, here's what I say to clients who come in who are common law, who believe that they are protected simply because they've lived together longer than a year. It's simply not true. If one of them were to pass away, the other would not inherit anything. So currently, under our civil code, common law spouses do not inherit from each other. So there's no affiliation or lineage between them. And so one of the biggest and most important things they can do is draw up a will to protect each other.
And get it notarized by Nadia.
Absolutely.
All right. Nadia, thank you so much. Very valuable information,
thank you
Corrie.
so much.
We appreciate you being here. How
Thank
can
you.
people get a hold of you?
So on my website, it's lamarderiggi.com, and by phone, 514-484-2788.
Well, thank you very much, Nadia.
Thank you so
Thank you.
much. Coming up after the news, you do not want to miss this interview. We have Paula Toledo in the house. She's going to be talking about how she had to deal with the death of her husband by suicide, leaving her a single mom with children who were just 2 years old and 2 weeks old. She has become a huge inspirational speaker and a mental health advocate. That's coming up right after we return on Life Unrehearsed. We'll be heading out to news shortly.